Hello guys, welcome back to desilaw. I'm Swati Shukla, a final year law student and your tutor for today. So today we are going to discuss a very short, interesting, yet a very important topic in the legal field, which is judicial review. What it is, where it started, why it is important, what are the constitutional provision, pros, cons, everything, everything about the topic. So without further ado, let's begin. Judicial review. So, the concept of judicial review was originated in the United States of America in the famous case of Marbury versus Madison in the year 1803, where Sir John Marshall was the Chief Justice of the Supreme Court of the United States. Yes, you heard me correct. It was the United States for the first time where the concept or the doctrine of judicial review first started. In India itself, the power of judicial review is conferred with the Supreme Court and the High Court. So both the courts has the power of judicial review. And the doctrine of judicial review is so important that it is included in the basic structure of the Constitution. Means it cannot be amended by any act of the Constitution. It have to be it should be left untouched. We cannot touch it. We just cannot amend it because basic structures are set not to be amended. So, judicial review is one of the key feature of the basic structure of the Constitution. The second thing that we are going, or rather I am going to discuss about it, what does it mean? What is judicial review? What it means actually? So, judicial review, we can define it from the term itself, like judicial review. So, judicial review is basically a examination, a re-examination, a scrutinization, or basically we could say we could look like the judiciary can look the decisions that are made by the legislature before execution, before before enactment. So any of the decision that is made by the center or by the state, by the legislator, or by any of the legislation, like by the supreme legislation or by the subordinate legislation or by the executive, the judiciary has the power to review it, to re-examine it, to scrutinize it basically in a very judicial way. So this is a power that is only conferred with the judiciary. This is what we call as judicial review. Reviewing the decisions, the reviewing basically the decisions that are being made. So it's the power that is with the judiciary, and this is the basic or the fundamental meaning of judicial review in a very lucid language which I am saying. So this is judicial review. Now, the concept of judicial review was made in famous Indian cases like the Keshav Nanda Bharti case, the Minerva Mills case, the nationalization of the bank case, the Kolaknath case. So, in the following cases, the judicial review was being enacted. Next, we will come to know that why it is important, why judicial review is so important. See, judicial review is so much important because it gives a federal character to the union, because the Supreme Court is the ultimate and the highest court of all. So the people would have a faith in the court that if a decision is not in their favor in the lower courts, they can approach to the high court because they would have a faith or a sense of trust to the court. So that if a decision is made or is about to made, the judicial, the adjudicators could again review it or scrutinize it and re-examine it, and on re-examining, if they found that the enactment or the decision is infringing any of the rights of the Constitution, the judiciary has a power to claim it null and void, or any of the decision which is ultra virus, the judiciary has the power to reject it, to annul it, to completely say that it is null and void. So this is a power that is available to the judiciary. So I hope it is clear with the meaning that what judicial review means: reviewing, scrutinizing, or re-examining the decisions that are made by the court. Next is, what are the constitutional provisions that deal with it? So coming back to the constitutional provision, there's no particular provision that mentions about the judicial review in particular. It is nowhere mentioned in the Constitution, but it is said in a further article where the jurisdiction lies completely upon the Supreme Court, where it could re-examine and it can review the decisions that are being made in the in some of the sections. So the sections that are very important, which I'm going to discuss, are as follows. So yeah, let's discuss with the constitutional provisions of the judicial review. So, though the term judicial review is nowhere mentioned in this in the Constitution of India, still there are a lot of articles which were like which explicitly confer the power of judicial review to the Supreme Court and the High Court. To deal with, there are certain articles like Article 13, which says that any law that are made inconsistent or in derogation with the fundamental rights can be declared as null and void. Article 32, where it empowers the Supreme Court to order decision and writs for the infringement of fundamental rights if one moves to the court for that matter. Then comes Article 131, where it gives original jurisdiction to the Supreme Court for the dispute between interstate and center state dispute. Article 32, where it gives appellate jurisdiction for the jurisdiction to the Supreme Court for in constitutional cases. Article 133, where it has the appellate jurisdiction to grant decision in case of civil cases. Article 134, where it has appellate jurisdiction to deal with the cases of criminal cases. Then it has Article 134A, where it deals for the appeal of a case from High Court to a Supreme Court. Then there are way more articles, which if I start to begin, the video will be too long. So yeah, there are a lot of articles which deal with it, like Article 135, 136, and a bunch of articles. More articles are there because articles are never ending. So yeah, this was a short review of the topic of judicial review. I hope it's clear with it. And if you guys have any problem, put your problems in the comment down below. And till then, have a great day.